So the Seventh Circuit recently held expedited oral arguments on the issue of whether or not a ban on so-called assault weapons and also a ban on so-called large capacity magazines was consistent with the Supreme Court's ruling in Bruin. So let's talk about this. But real quick before we jump into this video, if you think assault weapon bans and magazine bans are clearly unconstitutional and violate Bruin, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I will leave a link to them down below. As I mentioned in the intro, in this video, we're going to be talking about some critical oral arguments that took place in the Seventh Circuit about whether or not a ban on so-called assault weapons and also a ban on so-called large capacity magazines is in fact consistent with the Constitution, if it's consistent with the Second Amendment, and also if it's consistent with the Supreme Court's recent ruling in Bruin. Last week, the Seventh Circuit held oral arguments in a case which challenged the new Illinois state law, which banned so-called assault weapons, essentially AR-15s and a bunch of other firearms, and then also magazines that they claim are large capacity. And these oral arguments did not really go well for the pro-2A side, mainly because the judges on the panel during this hearing were outright showing that they had a hatred for firearms, that they have a hatred for the Second Amendment, and also they have huge disdain for the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruin. Now, for those not aware, the hearings that took place were on multiple cases challenging the state of Illinois' assault weapons ban, and also some city ordinances and restrictions on the possession of these types of firearms. The three main cases were Barnett v. Raoul, Herrera v. Raoul, and then also Bevis v. Naperville. In Barnett v. Raoul, the plaintiffs challenged the state of Illinois' Protect Illinois Communities Act, also known as the PIC Act. The PIC Act is the state of Illinois law that recently banned the sale of all those items, the AR-15 rifles, and then also large capacity magazines, or what they claim are large capacity magazines. Recently, a district court judge, Judge McGlynn, issued a ruling which granted a preliminary injunction against those state laws. He found that the state of Illinois' assault weapons ban and their magazine ban was inconsistent with the Supreme Court's recent rulings in Heller and Bruin, and therefore he put a temporary halt on its enforcement. Of course, the state of Illinois didn't like that. They didn't like that the injunction was issued, so they went up to the Seventh Circuit and they sought a stay of that injunction. And ultimately, the Seventh Circuit granted an emergency stay of that judgment in the favor of the state of Illinois. Then there were questions whether or not maybe we would get the Supreme Court to step in on this issue before the Seventh Circuit could essentially hear these cases. Essentially, to avoid the Supreme Court stepping in early, the Seventh Circuit decided to expedite all those hearings, and those hearings took place last week. And really, the question for the Seventh Circuit panel was whether the Illinois ban on AR-15s and similar firearms, as well as their magazine ban, whether or not it's valid under the Second Amendment, and whether that law is consistent with the Supreme Court's ruling in Heller and Bruin. The three judges that heard the arguments were Easterbrook, Wood, and Brennan. To say that the panel here was not Second Amendment friendly is really an understatement. Judge Easterbrook is one of those judges who's very anti-gun. He was the original author, I believe, of the McDonald decision that was reversed by the Supreme Court. So, of course, Easterbrook is very anti-gun. Judge Wood is also not really much better. The oral arguments that took place last week really show that these judges had a disdain for the Second Amendment, and also that they did not like what the Supreme Court did in Bruin at all, and that they are going to actively resist what the Supreme Court said in Bruin. First, the state's attorneys seem to rely heavily on the whole interest balancing arguments. The state's attorney argued that despite Bruin saying that the two-step approach cannot be used, the state's attorney was advocating still for intermediate scrutiny and still the public's interest. Essentially, what the state of Illinois' attorney was arguing for was some sort of backdoor way to get in their public interest arguments, although Bruin said that that was no longer appropriate. The state argued that they are banning these firearms because they are dangerous and unusual items, and that they are used in mass casualty events. They argue that this is the why behind the law, and that the public interest makes this ban constitutional. Again, this is an attempt to backdoor in interest balancing that was expressly rejected by Justice Thomas in the Bruin decision. Judge Wood talked about the whole dangerous and unusual analysis, and she called it a dangerous/unusual test. Again, this panel during the arguments is outright ignoring very clear statements by the Supreme Court that they made in Heller and Bruin. The true analysis would be dangerous and unusual, but here Judge Wood, who said that she was reading the opinion very thoroughly, wouldn't even acknowledge that it's dangerous and unusual. She called it dangerous/unusual. The state of Illinois' attorney went on to argue that AR-15s are not arms protected by the text of the Second Amendment, again, because they are dangerous and unusual. Here, there was a huge section of the arguments where the court, specifically Judge Easterbrook, focused on machine guns, grenades, Stinger missiles, and other arms not at issue in this case at all. This essentially was an attempt to create a diversion to avoid the arms that are actually in question in this case. The AR-15 is one of the most common firearms owned within the US by law-abiding people for lawful purposes. But the court would even push back against that type of common ownership claim, saying that the statistics on ownership is not conclusive, that the statistics that were put forward don't show how many are in the possession of civilians versus law enforcement, so they wouldn't even acknowledge that the AR-15 is very common within the US. Again, at every point during the oral arguments, there was heavy resistance by the judges. They also seemed to not want to follow the Supreme Court's Bruin decision and the analysis outlined in Bruin. Judge Easterbrook called the Bruin decision and analysis circular. He called it circular multiple times during these arguments and almost scoffed at the writings of Justice Thomas in Bruin, and again just showed a disdain for the opinion in Bruin. He also attacked the Pro 2A attorneys multiple times and claimed that Heller has never addressed what type of arms are protected under the Second Amendment, when in fact we all know under Heller, Bruin, and even Caetano, the Supreme Court stated arms in common use for lawful purposes are clearly protected by the text of the Second Amendment. But the Seventh Circuit doesn't like that fact, so what they tried to do is say that there was no precedent to that regard, that there was no definition about what arms are protected or what arms are included, and then they tried to claim that AR-15s are so similar to M16s and grenades and they're so dangerous and unusual. Then the judges here also even talked about the ATF and their authority under the NFA and GCA to ban bump stocks. And one of the judges, I believe it was Easterbrook, said that bump stock bans are permissible because bump stocks are machine guns. And Judge Easterbrook even mentioned that he believes that the Supreme Court will eventually take up that Cargill case and review bump stocks and the whole machine gun element. But even focusing on that, it's hard to understand why they're bringing that in because, again, the bump stock lawsuit, the Cargill lawsuit, and some of these other ones is not a pure Second Amendment challenge like we're dealing with here in these Illinois assault weapon ban cases. The ATF bump stock bans are more of administrative law questions about what authority the ATF has under the GCA and the NFA and what authority they have to engage in this rulemaking process that they're engaged in. So again, it was really out of place that the judges kept trying to insert some of these things. Ultimately, I think this case will be a loss for our side. I think at this point, listening to oral arguments, I don't think anybody could say that we would win this. The question then becomes what happens from there. The plaintiffs will have the option to take this case en banc in the Seventh Circuit or ultimately try to go straight to the Supreme Court if they want. Depending on how Judge Easterbrook botches this decision, because I would anticipate that he will write this opinion, based on what he says, maybe how much he goes straight after the Supreme Court or straight out refuses the Supreme Court's Bruin decision and some of these other decisions in his opinion, I think that will dictate maybe what the plaintiffs will do in this case, whether or not they will take this en banc or just decide to take this straight to the Supreme Court. So I think it's really going to all depend on what Judge Easterbrook says in his opinion. So for those of you in Illinois, I know this isn't good news. I know maybe some people were hoping for a positive outcome out of the Seventh Circuit 3-judge panel, but just the judges that are on this panel, this is not going to happen. I think we all kind of knew going into this that it was very unlikely, but we were curious, I guess, how the panel would address this during oral arguments. And again, they were very anti-gun during the oral arguments. But if we get any more information, if anything else develops, I will let you all know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.